or here in our case, when CAIC 20-0019 Phoenix Union versus Estrada. Each side will have 20 minutes to present their argument. Appellant, you may reserve as much of that time as you want for rebuttal, but you'll have to keep track of the time yourself. We have a small clock at the bottom of the screen. I hope you can see it, or you can keep track on your own clock, however you want to do that is fine. We're recording the argument, so when you begin your argument, please identify your client and yourself so that we can keep everything straight if we go back and review the argument. In a couple of days, the argument will be up on YouTube, so you can go watch and see how you did. We've read the briefs and looked at the record. We've conferenced the case, so we're familiar with the facts and the issues. So when you begin your argument, just start right off into what you would like to talk with us about. Counsel, you may begin.
Hi, my name is Lynette Flanagan, and I represent the petitioner, Phoenix Union High School District, and the Alliance in this matter. The issue before you is pretty straightforward. Did the administrative law judge err by disregarding uncontroverted evidence showing that Ms. Estrada had a change in her earning capacity from the time of the original award in 2013 to the time the petition to rearrange was filed? Now, Ms. Estrada's claim was closed with an unscheduled permanent impairment, and the matter was sent to the Industrial Commission for a determination as to whether she had a loss of earning capacity. And the Industrial Commission is the one that made that determination, not the carrier. And on June 7, 2013, they issued their findings and award that Ms. Estrada had a loss of earning capacity. She continued to receive benefits under that award and continues to this day. Now, the petitioners filed a request for rearrange because there was a change in Ms. Estrada's condition. And there's two main ways that the carrier could get rearrangement. The first is if there is a change in her physical condition that increases her earning capacity, or under 3 of the statute, whether there is an increase in her earning capacity. Now, the original award issued by the Industrial Commission on June 7, 2013, that is final. We don't dispute that's final. The petitioners were not trying to relitigate that issue. Rather, under the statute, they are seeking rearrangement. And the evidence before the administrative law judge supported rearrangement under both prongs. Prong 1, a change in her physical condition, and prong 3 under the statute that her earning capacity had increased. And the evidence at the time, well, let me go back. So what controls is Gallegos, and that's the Arizona Supreme Court decision that addressed the very issue of what the comparison is for a rearrangement. And in Gallegos, they said you need to look, whether right or wrong, at the findings and award issued by the Industrial Commission originally. So we need to look at the June 7, 2013 findings and award. And at that time, the Industrial Commission found that only 25 hours or part-time work was available to Ms. Estrada within her work restrictions. Those work restrictions were 10-pound lifting, no repetitive work, no overhead work. Fast forward to the time of the petition to rearrange, and things had changed. You had the uncontroverted evidence before the administrative law judge was that both doctors found that Ms. Estrada could work a 40-hour work week. You had uncontroverted testimony from both labor market consultants saying that 40-hour work week, 40 hours were reasonably available to Ms. Estrada. So under the statute, the petitioners showed that there was a change when you compare it to the original award to the time of the petition to rearrange. And it was error for the administrative law judge to just disregard that. The second piece is the physical piece under the first prong of the statute. We have both doctors saying that her condition improved. We also have a change in the work restrictions. When you compare it from the 2013 findings and award, the 10-pound lifting restriction, to the testimony at the time of hearing when a Dr. Letterman, who is the applicant's physician, who the administrative law judge accepted his opinion, he said, well, the work restrictions are the ones that were in the functional capacity evaluation. Well, those were greater, they were less onerous work restrictions. She had a greater lifting ability, and she could do other things. The labor market consultants both identified other jobs that she could do within those work restrictions. And those other jobs included light assembly work, which also was available at a 40-hour work week.
When you said excuse me, I'm sorry. When you said that he was referring to the FCE, though, that wasn't what the final order was back in 2013, though. It didn't consider the FCE. So that comparison about restrictions were what we're supposed to be looking at, are they? Because aren't we, just as you said at the beginning, restricted to what the award fact findings were, and the award fact findings from our reading didn't include the FCE as a basis.
Sorry, that's correct, and maybe I misspoke. So when Dr. Letterman testified at the hearing, his work restrictions at the time of hearing referred to those of the functional capacity evaluation. So the now is the functional capacity evaluation if you take Dr. Letterman's, and those work restrictions are different than what was in the findings and award. And that difference, based upon the testimony of the two labor market consultants, which also was uncontroverted, there are other jobs available to her at the 40-hour work week, which also would show an increase in her earning capacity. And it's our position that it was error for the administrative law judge to disregard uncontroverted evidence from the experts that clearly showed there was a change in her earning capacity. Thank you.
Thank you.
Cancel. You may begin your argument.
Oh, Lynette, are you done?
Yes.
Okay, I'm sorry. Good morning, Your Honors. My name is Dennis Kurth. I'm with the law firm of Snow, Carpio, and Wheatley, and I represent the respondent employee, Mrs. Estrada. In my opinion, and based on the briefs, I believe that this is a classic preclusion case. The judge didn't ignore uncontroverted evidence. The judge applied preclusion. And the judge correctly applied preclusion if you look at the case law cited in the award. The only question here is the application of Gallegos to let the petitioners escape and avoid the application of preclusion. Now, the Nolan case, which of course was the memo decision that you were on the panel of, Judge Howe, says that yes, it seems to agree with the petitioner's position, but my understanding is that oral argument wasn't requested in the Nolan case. And of course, the Nolan decision was a memo decision, which is not precedential. I'm hoping, Judge Howe, to give you a different perspective based on my 45 years of experience doing nothing but representing injured workers under the workers' compensation statute, and give you a little bit different view of what was going on in the Nolan case and what's going on in this case, and why, in my opinion, this is not, nor really was Nolan, a good case to apply Gallegos to relieve the carrier of its mistakes. First of all, I would like to tell Your Honors that these awards, these what we call loss of earning capacity unscheduled awards, these are very, very critical awards that the claimants have to be disabled from doing their regular employment in order to get. These claimants often live on these awards with no other income because they can't work. They rely on the finality and the certainty of these awards just like they would a Social Security check. That's how important important. They are. Finality is crucial to these awards, and it's crucial for these injured workers. The carriers here, like Lynette says, that the Industrial Commission made this determination that Mrs. Estrada could only work 25 hours. In reality, they didn't. The carriers know how to manipulate the system of permanent awards when they close cases. They file labor market reports, and unless the claimant is represented and knows to file his or her own labor market report, the carrier gets whatever they want in the award. That's what happened here. They filed a labor market report that said, that asked the Industrial Commission to set it based on an earning capacity of 25 hours a week. No doctor had limited the applicant or Mrs. Estrada to 25 hours a week. They got exactly.
Didn't that benefit your client at that point?
Certainly, yes. My client, Judge, was unrepresented. She had no idea, just like just about
she would prefer a recommendation that says she's only capable of working 25 hours. Her benefit was greater as a result of that, was it not?
That's correct.
And if the opposite had happened, if the initial award had been based on an ability to work 40 hours, and there were new evidence now that her condition has worsened, she's not capable of working more than 25 hours, wouldn't you want to come in and rely on what the current assessment is?
Absolutely. Yes, Your Honor. Absolutely. That's true. What I was trying to explain, though, however, is that the carriers know how this system works. Now, what's important to this case and preclusion is they had the evidence that she could work 40 hours. They had the evidence at the time the award was issued that jobs were available for 40 hours. They even gave it to the Industrial Commission 3 days after the award. What they didn't do was file a request for hearing within 90 days. They also could have rescinded the closing notices and submitted an updated labor market report. They knew how to work the system to get what they wanted. They made a couple mistakes, and now they're asking the court to relieve them of their mistakes. Getting back to
they're not asking to have any money refunded for the years that if in theory it was a mistake. They're just saying going forward, this is the assessment and there's a capability of working 40 hours. So it's going forward seems different.
Oh, it's a little bit different, but what I wanted to point out, the danger, in my opinion, based on my experience, the danger of codifying or putting a rule like Nolan into an opinion is that it's not going to hurt just my client, Mrs. Estrada. It's going to hurt badly thousands of injured workers who live on these awards. I mean, look what happened in Nolan. And this is what I wanted to give the court a little bit better perspective about, because there wasn't oral argument in Nolan. And I don't think the claimant had a good chance to explain what goes on here. Look at what happened in Nolan. In Nolan, there was a stipulation between the lawyers for the parties that the injured worker could work 20 hours a week. I thought, and I still think, that a stipulation signed by a lawyer binds the lawyer, is the lawyer's and his client's word about the facts. So this award in Nolan was based on the stipulation of the parties. The ink wasn't even dry on that stipulation when 2.5 years later they repudiated it, and there was no actual increase in the claimant's working ability. Nothing had changed. Claimant hadn't worked. Claimant hadn't gone to school, gotten any additional education or training. What the carrier did was they set up an independent medical exam. Said the IME predictably said that the claimant could work 40 hours a week. They therefore get a labor market report that projects a higher earning capacity based on 40 hours a week. They file a petition for rearrangement. It's that easy in a situation where there's no actual increase in earning capacity for a carrier to do this. The danger of putting the Nolan opinion, putting the Nolan principle into an opinion based on this case, for example. There's no finality, there's no certainty that these awards are final. The carriers can do this at any time. If you apply Gallegos to Nolan and to the facts in this case, there is absolutely nothing to stop carriers from changing thousands of these permanent awards that injured workers, permanently disabled injured workers, rely on to live. Nolan, I mean, to be honest with you, Nolan is a better case, in my opinion, to illustrate the problem with applying Gallegos in this type of situation. I had a case that resulted in a memo decision. Obviously, I can't cite it, back in 2012 in the Court of Appeals. And in that decision, the court said that a change in medical opinion alone, without showing that the injured worker has gotten any new education or new work experience, is not enough to show an increased earning capacity under 23-1044 F3. Now, the interesting thing about that case, because not just that it conflicts directly with Nolan, but the interesting thing was it was the same doctor that the carrier used in the Nolan case to change the applicant's permanent award. It's very, very easy for the carrier to get one of those doctors, and this doctor is still making a very fine living doing this 8 years later, because he now appears in the Nolan case. So all they need to do is get a hypothetical opinion from a doctor that a claimant can work 40 hours, get a labor market report that says they have a higher earning capacity, and change the award. This is what I think needs to be prevented under a statute that is supposed to be liberally construed to benefit the injured worker. It's like turning the law on its head and taking the Gallegos case, a very liberal decision from the Supreme Court that was designed to effectuate the purpose of the workers' comp law, the humanitarian purpose of helping the injured worker, and using it instead to help the insurance carrier change these awards strictly on a hypothetical basis and hurt the injured worker. So that's why I think that it's not a good idea to do this. The statute, the rearrangement statute, is there for a very clear purpose. If a claimant who's on one of these permanent awards gets a job, they file annual reports, the carriers monitor the annual reports, the statute gives them a way to change the award based on the actual increase in the claimant's earning capacity. The problem—
Counsel, why hasn't that occurred here? It seems like her earning capacity has increased.
It hasn't occurred here, Your Honor, because the claimant never returned to any form of work after the award was issued in 2013. She kept filing annual reports, but since she wasn't working, there was no proof that she had an increase in her earning capacity. Additionally, she had no further education or training.
Well, I'm confused. So she can determine herself whether she has an increase in capacity?
No, she's just going along living her life. All I said was she didn't return to work and didn't get any additional education or job training. So there was therefore no actual increase in her earning capacity. There's simply now what we've got here, instead of the carrier, well, they actually did. They went out, they got an IME, and the IME said can work 40 hours a week, just like the evidence was 7 years ago. And then they hire a labor market expert to write a report. So it's all hypothetical. That's the danger. The danger is letting the carriers now have a rule of law codified in an opinion that endorses that type of practice. In my opinion—
I'm sorry, but the practice you're saying is that somehow the employer would be incentivized to have an initial award that would be 25 hours a week, and then they'd come back 7 years later as a gotcha and say, well, no, that wasn't a necessary finding back in 2013 the 25 hours a week. We're going to change it to 40. We're going to do another IME. Now we're going to say it's 40, and we're going to come back and get you. I don't understand where we have an award that said 25 hours. It's not, the award said 25 hours. Nobody challenged that decision. As Judge Catani said, it was a detriment to it favored your client. So your clients had this favor for 7 years on a finding that you say was erroneous because she was capable of working 40 hours a week even back then. So how is that something that from a global perspective is going to change the way that applicants and employers engage in these IC findings?
Well, you're right, except to the extent like my opposing counsel says the Industrial Commission made that determination. They didn't. They just endorsed the determination or the recommendation that the carrier gave them. The Industrial Commission didn't weigh competing evidence.
But what other findings can we look to in order to, and what other findings can the Industrial Commission look at other than going back to what is stated in that 2013 finding, the 25 hours? I mean, to say, how do we 7 years later go back and undo that finding because you say it was really just an adoption of a recommendation as opposed to an actual finding of what she was capable, how many hours she was capable of working?
That's right, Your Honor. You can't necessarily undo that. See, that's the point that I'm saying about preclusion. Preclusion says you can't sit on evidence that you had in 2013, let an award become final when you knew how to protest that award and change it and correct that mistake and then bring it up 7 years later. That is the essence of preclusion. If you had the evidence, whether you litigated it actually or you could have litigated it, as in this case, you're precluded from doing that in the future. Now, that may be a harsher result than what you think might be indicated, but that is the law of preclusion that the judge applied. Basically, all I'm saying, Judge, is that the Nolan case is a better illustration of the problem of making this Nolan principle into an opinion and making it the law. It's going to allow things like what happened in Nolan, which in my opinion was completely outrageous, to become the law and to let carriers do this in the future. There will be nothing to stop them if you publish an opinion that endorses what happened in Nolan. How can you possibly endorse a result that allows a carrier and their attorney to repudiate a stipulation that the person could do 25 hours of work 2.5 years later with no other evidence other than a independent medical exam and a labor market report on the carrier? That's the problem. My case is not necessarily the best illustration of that, but it is an illustration of sometimes the painful application of the legal doctrine of preclusion. It may be painful, but when you look at this, Judge, look at the difference between these two cases, Gallegos on one side and Nolan, and my case, Estrada, on the other. In Gallegos, the first footnote in the Supreme Court's opinion talks about the actual facts, the true facts of the case, which were that the claimant was not able to work without a loss of earning capacity. They did the best they could in a liberal interpretation of the law to implement the actual true facts and give the injured worker who was facing forfeiture of his compensation on a permanent basis and give him a remedy. That's what they were supposed to be doing. The carrier here, Your Honors, does not approach the bar with the same position that Gallegos did. They are not an unsophisticated, badly, permanently injured worker who desperately needs the compensation. They are not the beneficiary of the statute like the injured worker is. and they knew how to correct their mistake. They just didn't do it. And they've never explained why they didn't do it. This is a whole different situation. Gallegos was a liberal interpretation of the law, and it was a fair and reasonable way for Judge Feldman and the Supreme Court to give the claim. Social legislation like the workers' compensation law must be liberally construed. That's a statutory construction rule that goes back to the idea of social legislation, remedial legislation liberally, is to what the courts called back then suppress an evil and support a remedy. Here, if you let the carriers do what they did in Nolan specifically, you're supporting an evil and suppressing a remedy. The only thing that can happen if you apply Gallegos to this case, the Estrada case, is to create a rule to endorse the practice that the carrier did in Nolan, repudiate a stipulation, hire an independent medical exam with the same doctor that does it over and over and over, and then let them take away the claimant's award. They knocked off $500 a month of the claimant's award in Nolan just by doing that. What's to stop them from doing that in thousands of cases? Thousands of injured workers depend on these awards. They need finality and they need certainty. To let a carrier do what they did in Nolan is really wrong. It doesn't wait any purpose of the workers' comp law. In Nolan, Judge Howe, I know the court said in Judge Thuma's opinion that they wanted to effectuate the purpose of the workers' comp law. And that's good, but I think the court got off track in actually doing that. The purpose of the workers' comp law is humanitarian. It's to help the injured worker. It's not to endorse a procedure where the carrier can change a permanent award at any time they want just by getting an medical exam. So, liberal interpretation of the law is one of the last vestiges that we have, that claimants have, of the grand bargain, the trade-off in the workers' comp law. Everything has been going backwards for the claimants in the grand bargain over the last 30 years. Benefits have been cut back. Workers have been misclassified as independent contractors instead of employees. Medical benefits, for example, the adoption of the ODG in Arizona, have been cut back. There's nothing left really for claimants now other than the liberal interpretation of the law. And I submit to you that it's really not consistent to apply a case based on liberal interpretation to help the injured worker in a fashion now that the injured worker badly. It's the precedent that I think is going to be set if you put this into an opinion and endorse the practice in Nolan.
Thank you, Counsel. You ended right at your time. Thank you very much. Counsel, rebuttal?
Yes, just a few points that I'd like to point out. There was no stipulation in this case. There was findings by the Industrial Commission, as is identified in their findings and award from June 7th of 2013. And those are what become the comparison point. Now, this isn't about issue or claim preclusion. It's not. Nobody's trying to relitigate that findings and award from 2013 to say, hey, Ms. Estrada, we overpaid you for the past 8 years. That's not what's going on. There was a petition to rearrange, which is what is permitted and set forth in the statute. And that is what is being done. And the comparison is the 2013 award. It's not about issue preclusion. It's not about a stipulation. It's not about a what ifs. The same situation, if Ms. Estrada in 2013 had a note from Dr. Letterman saying she could not work at all, and she didn't protest the findings and award, and then she filed a petition to rearrange later on, she would have prevailed because the comparison would have been the 2013.
Well, she wouldn't be filing a petition there if she was not able to work. Presumably her benefits would be higher.
Correct.
She wouldn't be seeking to rearrange.
Well, but if she didn't, if she had, if at the time of the 2013 award, which it was based on a 25-hour work week, the next day, if she got a note from her doctor saying she couldn't work at all, but she didn't protest the 2013 award and got the LEC benefits based upon that, it wouldn't stop her from 5 years later saying, hey, look, I have this note saying I can't work. And therefore, it should be rearranged. And even though she may have had it at the time of the findings and award, it doesn't matter based on Gallegos, because the facts, whether right or wrong, that were in the findings and award of 2013 are what govern the comparison. Thank you. That's all I have.
Thank you, Counsel. We appreciate your argument today. We'll take this matter under advisement and we'll issue a decision in due course. Thank you very much. We stand adjourned.
Thank you.
Thank you, Judge.
Thank you.